A recent U.S. Department of State enforcement action has put ITAR compliance back in focus. On 13 August 2026, the State Department announced a $36 million settlement with BAE Systems Inc., resolving 104 alleged violations of U.S. defense export control requirements. The case involved issues including unauthorized exports of technical data and other defense-related controls. For defense exporters, the useful question is not simply what happened to BAE. It is, what can companies learn from the case about managing ITAR compliance? The International Traffic in Arms Regulations, or ITAR, are administered by the U.S. Department of State's Directorate of Defense Trade Controls. ITAR controls the export and temporary import of defense articles and services, including certain technical data. That means compliance is not limited to putting a controlled physical product into a shipping container. The handling and transfer of controlled technical information can also create an export control issue. And that is one reason technical data management matters in defense supply chains. According to the State Department, the settlement resolves 104 violations of the Arms Export Control Act and ITAR. The violations included unauthorized exports of technical data, defense services, and other conduct involving defense trade controls. The State Department also says that BAE voluntarily disclosed most of the violations and cooperated with the department's review. The agreed civil penalty is $36 million. Half of that amount, $18 million, is suspended on the condition that it is used for department-approved compliance activities. The settlement also includes additional compliance measures. The first lesson is about technical data. In a defense business, controlled information can move through engineering teams, suppliers, contractors, and international operations. That means companies need to understand what information is controlled, who can access it, where can it be transferred, and what authorization applies. A compliance program that focuses only on physical shipments can miss other forms of controlled transfer. The second lesson is authorization. ITAR-controlled activity may require an appropriate license, agreement, or exemption, depending on the circumstances. Before transferring controlled defense articles, technical data, or defense services, businesses need to establish whether the proposed activity is authorized. This becomes particularly relevant when a transaction involves multiple countries, foreign personnel, contractors, or related companies. The question is not simply, can we send this? It is, what legal authority allows us to make this transfer? The third lesson is supply chain control. Defense programs often involve companies operating across several jurisdictions. That creates multiple points where controlled items, technical data, or services may be accessed or transferred. Companies should therefore understand their supply chain beyond the immediate customer. That can include contractors, suppliers, foreign subsidiaries, service providers, engineers, technical teams. The objective is to know where controlled material goes and who is permitted to access it. The fourth lesson is about the compliance system itself. Policies are only useful if employees understand them and the controls operate in day-to-day business. For defense exporters, that can mean clear procedures for classification, licensing, technical data access, record-keeping, employee training, and escalation of potential violations. The BAE settlement also includes compliance-related requirements, reinforcing the role of internal controls and remedial measures in resolving export control violations. The fifth lesson is straightforward. Build the compliance check into the transaction before the transfer takes place. Before an ITAR-controlled transaction moves forward, companies should be able to answer 5 questions. What is controlled? Who is receiving it? Where is it going? What authorization applies? and what records demonstrate the decision. That approach helps connect export control requirements with the company's actual business process. The BAE case is a useful reminder that ITAR compliance extends beyond the physical movement of defense products. Technical data, services, authorizations, people, and supply chain relationships can all form part of the compliance picture. For more practical updates on customs, export controls, and international trade compliance, subscribe to Ask the Customs Manager.